Thanks, Les. God. I don't know if I can handle this. I got 7 kids. I'm used to shouting and speaking very loudly. I appreciate the opportunity to be here. I am supposed to talk to you about the Lynch lawsuit. Be happy to do that. The timing of this is very good because we have just reached a milestone in the trial. So let me back up for a minute. How many of you have not heard about the Lynch lawsuit? Okay. You know, every time I go, matter of fact, for the last 2 years, as I've gone around and had an opportunity to speak to groups like this, speak to groups that had an interest in forestry, I have invariably I've talked about the Lynch lawsuit, and yet there's still a lot of folks that do not know. So let me, for those of you who have not heard about the Lynch lawsuit, let me give you a little bit of history. Some of you may recall back about 12, 14 years ago, there was a lawsuit filed. It was John Knight, who is a representative from Montgomery, had filed that lawsuit back, well, again, probably 12 or 14 years ago. It had to do with funding of 4-year colleges. And the suit alleged that some of the 4-year colleges were being underfunded. It was based on racially discriminatory motives, and that suit dragged on for about 10 to 12 years. Now, during that process, the plaintiffs' attorneys introduced not only evidence about funding and disparate funding to some of the 4-year colleges, but they also tried to make a similar argument on K12 funding. Well, what the judge did is he said, in a ruling when they introduced that, he said, well, that may be, but K12 is a different issue. So he set that issue aside, and the 4-year college case continued on. After about 10 to 12 years, they finally settled that, and that was back in 2007. The plaintiffs' attorneys then took that K12 piece of it and filed that lawsuit alleging racially discriminatory motives that resulted in underfunding of predominantly rural schools. And they filed that lawsuit in Northern District Federal Court in Alabama in Huntsville. And that was back in 2008. Now, we saw that, I and my governmental affairs guy kind of saw that in the paper. We didn't pay much attention to it. But about a day after the story hit the paper, we had an attorney call and said, did you see this suit has been filed? And we said, yeah, we did. He said, well, you better pay attention to it. So when we began to dig into it, we saw, and the alarm bells started going off, and we said, you know, this thing is serious. It has a potentially very large impact on forest landowners and on farmers. So I immediately went to go see the governor and his legal advisor, and I said, the lawsuit named the governor and it named the state of Alabama. And what it said was basically the funding formula or the restrictions that are placed on the ability for local counties or for counties to tax or generate property tax are grounded in the 1901 Constitution, and those restrictions were put in place with the intent to restrict funding to public schools, which at that time was, you know, a racially discriminatory motive to disenfranchise African Americans. And so that's kind of the argument of the suit. It named the state, it named the governor. I went to the governor and I said, what are you going to do about it? He said, well, we're going to, we got to file our papers, but you need to go see the Attorney General because he's the one that will be defending the state. I went to see the Attorney General at the same time. My counterpart at the Farmers Federation was kind of making the same rounds. And we converged at the Attorney General's office and talked to Attorney General King and said, what are you going to do? He said, we're going to vigorously defend the state, which meant we're going to vigorously defend our current tax system. Now, let me give you a little quick primer on what it would mean, what the plaintiffs are asking for. The plaintiffs are alleging that the funding is inadequate, that there are racially discriminatory motives in that, and as a result of that, they're asking the federal courts to throw out our current property tax system. And let me explain what I mean by that. As you look at your property taxes, you take in essence, you take a value and apply the millage rate. In Alabama, you take a value and there is a differential assessment component. And utility property is assessed at 30% of its value. Commercial business property is assessed at 20% of its value. Cars, boats, motorcycles are assessed at 15% of their value. And residential property, ag property, farmland, and timberland is assessed at 10% of its value. So you take that, and if you're talking about timberland, you're talking about a value, the value of the property times 10%, and apply the millage rate. In our case, we also have a current use provision. And that current use provision says that if you elect this, and if you are, growing trees or if you're growing crops, your property can be valued at that rate, and under the current use provision, that value is fixed based on a formula. Okay, so it doesn't, it fluctuates based on that formula. Right now, timberland, current use value for timberland, depending on the quality of the land, is somewhere an average probably around $550 to $580, something like that as an average. So the way you calculate your property tax, if you've elected current use, let's say the current use value is $600, you'll take $600 an acre times 10%. They give you $60 as the assessed value, and you apply the millage rate. What the plaintiffs are asking for is for the judge to throw out differential assessment, to throw out current use. So if he gives them what they ask for, if he agrees with them, you throw out differential assessment and you throw out current use. Now, if you're in Pickens County, Alabama, if you're in Barber County, Alabama, maybe the difference between current use and fair market value is not that great. Okay? But if you're in Madison County, if you're in Shelby County, if you're in Baldwin County, then you may be looking at a difference between $600 an acre current use value and $6,000 an acre fair market value if it's got the development. So let's just say that there's no difference between current and fair market value. You're going from current, you're losing current use, you're going to fair market value times 100% times your millage rate. So your taxes are going up by 1,000%, by a minimum of 1,000%. If the plaintiffs are granted what they're asking for. Now let that sink in for a minute. 1,000%. Now, what a lot of people don't, what the general public doesn't realize, the press on all this is farmers and the big out-of-state timberland owners, which we try to help them understand that the vast majority of forest land in Alabama is owned by private family forest owners. But that's the way the press has been spinning this, that this is the big farmers, the out-of-state timberland owners. But remember I said that ag land, timberland, and residential property are assessed at the same rate. So as timberland properties will go up by 1,000%, so will the tax on that house in Auburn, in Montgomery, in Mountain Brook, in Huntsville. Everybody's property taxes, everybody's house taxes will go up by 1,000%. More than 1,000%. Okay, potentially. potentially. Okay, let me tell you a little bit. So, if I got your attention. Okay. This is for real. This lawsuit was filed. Let me explain to you the mechanics of how it would work. The plaintiffs are asking the judge to throw out current use, to throw out differential assessment, and then give the state legislature a year to come up with something new. Okay? I give you great hope. Okay? Okay, not only would the legislature have to come up within the course of a year with a new system, and theoretically they could implement the same thing that we got, but advocates of higher taxes would certainly be exerting an enormous amount of pressure to change what we got and raise taxes. Okay, so the legislature would have to pass this in a year, and it would have to be approved by the voters in that same one-year period. Now, if you follow elections very much, if there's anything on a ballot that even hints of a tax increase, the funny thing is voters don't usually approve it. And so it is highly unlikely that the legislature could pass something, take it to the voters, and then that could all be done within the course of a year. If that doesn't happen, then based on what the plaintiffs are requesting, it would go back to the federal judge, and the federal judge would then have, under his discretion, he could choose to implement whatever he wanted. Now, again, I don't get the warm fuzzies when I think about that. And that is to if any of you, I know we've got probably some attorneys in here, and I'm probably butchering some of the legal issues here, but it's really, really unusual. Matter of fact, there's a pretty substantial wall that's been built up by precedent to keep the federal government out of local taxation, out of the state's taxing authority. So that, as a matter of fact, that is one of the arguments that the state used to say the logical conclusion of this would interject the federal government or the federal courts into Alabama's ad valorem taxation system, and that's, the state's argument is that's highly improper for the federal government to be involved in that. Now, where are we? That suit was filed. We and the Alabama Forestry Association and the Farmers Federation, we have joined forces. We have hired an attorney who is working very closely with the state's defense team. The state's defense team is comprised of the Attorney General King hired the firm, or contracted with the firm of Maynard, Cooper, and Gale out of Birmingham. The attorney who is working on this case is former Chief Justice Drayton Neighbors, and we work very closely with him, trying to provide him information, working with him on assisting in any way we can. Our attorney has been up there at the trial every day. This has been going on for like 2 years. And we have been, again, doing everything that we possibly can. The trial judge is Linwood Smith. He is a Clinton appointee. When we first heard about that, we tried to find out something about Judge Smith. And we were told that he was left-leaning. And then as we proceeded on through, the next time I asked questions, some of the attorneys that had been following proceedings said, well, he's leaning a little further to the left now. And it seems, from what we can gather, that he sees this as his legacy, that he's going to do something for the school children in Alabama. And he is, matter of fact, at one point in court, when he was asked to rule on a particular issue, he told the plaintiffs' attorneys, he said, I really would like to rule for you. You just got to give me something else. And so he is predisposed to rule in the plaintiff's favor. We fully expect to have an unfavorable ruling. The trial began about 4 weeks ago. The last day of testimony was Tuesday of this week. We're going to go through probably about 4 weeks of some motion filing, and then there'll be another 2 weeks of some additional filing, and at the end of that period, they'll go through the final arguments. And we expect that we'll see some kind of decision out of this by mid-July, mid to late July. Now, as I said, we are braced for an unfavorable ruling out of the trial court. If that happens, then we are not, by the way, the Forestry Association nor anyone else is technically involved in this case. We have not filed any friend of the court brief at this point. We plan to do that if we get an unfavorable ruling. I suspect that the plaintiffs will appeal if, in the event that we get a favorable ruling, I expect the plaintiffs will appeal. So one way or the other, we'll probably enter officially at some point. But if we get an unfavorable ruling, we anticipate that the decision will be appealed to the 11th Circuit. The plaintiffs' attorneys do have, if the judge rules on one motion that they have already made, it will position favorably. It will position them to request their attorney's fees be paid by the state. If the judge grants that, then everything that the plaintiffs have spent to this point on attorneys, as well as everything going forward, will be paid by you and me. And in addition to the defense side of it. So that's what happened in the Knight case. That's one of the reasons that it drug out for years and years. The plaintiffs' attorneys had every reason to drag it out. And again, these are the same plaintiffs' attorneys. So what I'm telling you is this could drag out for a good period of time. It is in our best interest that we see a very quick resolution to this. Right now, we feel good about an appeal to the 11th Circuit because of the makeup of that court, but that could change, and anything could happen. And in anything that would happen, whether the legislature makes any changes, ultimately has to make changes, or the federal courts do, I can assure you the property taxes will be higher, and probably much higher. And so that's kind of where we are, where the case is. We have to date spent over $200,000. I'm going to make a shameless appeal here. This is something for us that's off budget, but there's no way we can not follow this thing through and to hopefully a successful or satisfactory conclusion. We could certainly use any assistance if anybody's interested in helping us out in the legal fees, because it's, we've got probably the best constitutional lawyer in the state of Alabama working for us, and hopefully, again, we can get this resolved quicker, sooner rather than later. But that's pretty well where we are. The stakes are high, and we will continue to fight that fight. If you want to, I'll on one of the tables out the back door, I'll leave a bunch of my cards, which will have our website on there, as well as my email address. Be happy to, answer any questions either now or at some point in the future. I kind of follow that. We've got Tom Saunders is our general counsel and governmental affairs director, and he works. He and I both are working very closely with the state and with our attorneys. So that's kind of where we are. Questions, comments? Yes, sir.
Yeah, Chris, any background work, preparation being made to work with the legislature we have now to have, you might say, a plan to be ready to go if we need it?
Are there anything being done in preparation if we have to go back to the legislature? Yes, as a matter of fact, we had that clearly in mind when we entered into the 2010 races. Let me give you a quick, this is a little bit off topic, but I think it's going to answer your question. I don't know whether y'all know this or not, but things, I mean, there's a new sheriff in town in Montgomery, and things have really changed. And you really ought to be proud, because your legislature's actually functioning, and they're doing a good job. And I'm telling you, things have changed. I'll give you a quick example. There was Tom Saunders went out to eat the other night to a restaurant. One of the favorite hangouts of a bunch of lobbyists, and you know, during legislative session, you would almost, no matter where you went around town, in the restaurants, you'd see lobbyists in with all the elected officials and everything, and whining and dining and all that. And Tom went in there with a couple of people, and the place was dead, except for one table. And there was about 6 senators sitting there buying their own dinner. You know? Now, I'm telling you. Now, if you own a restaurant in Montgomery, it's really a bad thing. I'm not kidding about that. These guys are really suffering, because it's really taking a lot of money out of the restaurant business. But all that to say is things have changed. Things have changed, and we worked very hard during the election. We spent a lot of dollars, and we stuck our necks out. And 89% of the people that we endorsed, won. And matter of fact, we had some of our counterparts around town said, "You guys are idiots," because we were endorsing challengers. And I don't know if you understand this, but if you endorse a challenger against an incumbent and the incumbent wins, that incumbent usually has a very long memory, and he makes you pay for it, or she makes you pay for it. We do actually have a few of those incumbents we went against that won that are kind of poking at us right now. But we work very closely with the leadership and the current leadership, and we collectively have, I think, as a forest community, are positioned very well, if something like this happens. We've got a pro-business, conservative leadership in the House and the Senate, and I feel very, very good about that, as good as can. Now, if it does go to the legislature, I can assure you that the pro-tax proponents, advocates, will be out. They'll be out there in full force, and they'll be pushing as hard as they possibly can. So it'll be a battle royale, but we're positioned as well as we can be, I think. So, yes, sir.
Of the tax differential rates, do you have any friends out there in the other states that have structures similar to ours?
41 states have a current use. 41 states have a current use system. Differential assessment, I think it's the number is probably 21 have some type of differential assessment out there. So that's one of the things that the plaintiffs were arguing is Alabama is unique. Alabama is unique. They're in placing limits on how much property or tax can be raised. Alabama is not unique. The funny thing about it is people, the public, when it comes to taxes, they have an aversion to paying taxes. I don't understand that. But, people want to keep their own money. And so it's not uncommon. Certainly current use is very common, some type of current use. And a differential assessment, there's 20-something states that have that. So, yes, there's other states that have that. Georgia, as you probably, some of you may have followed this, Georgia had a current use, they call it CUVA, current use valuation agreement. That's a 10-year agreement you sign up for to keep your property taxes down or assessed at current use. You could access that up to 2,500 acres before. Lee, do you remember? Anyway, sir? 2,000. But they just changed. They just passed 2 years ago, I think, where they took that 2,000 cap off of it. Right? Okay.
It's a 15-year agreement.
It's 15 years. Okay.
2 systems. The old system's still there. The new system is 15 years, and that.
Yes. So my point there is Georgia realized that their system that was forcing people to pay based on fair market value, was not in the best interest of the state. It was not in the best interest of the landowners, so they made those changes. Well, we got that. They were moving closer to where we were, or where we are. So, other questions? Yes, sir.
Yeah, if that's the case, since it's a federal situation, the decision on this by this federal judge could impact any states.
Absolutely.
They could be forced to do the same thing that we're doing once that federal judge makes a decision. So we ought to be reaching out to get some muscle power, money power, whatever, from other states to help count, not this in the head while we can.
Well, this decision will impact other states. Yes. As a matter of fact, we believe that there's money coming from outside of Alabama that's funding this. We believe that a lot of the other southern states have similar constitutions. They were put in place at about the same time, so you could make the same kind of argument. And we believe that they're using Alabama as a test case. If they're successful here, they'll roll it out in some other states. So yes, we do believe that. I have been talking to my counterparts, particularly around the South, and they just kind of sit back and, you guys keep it bottled up in Alabama. But that's the same sort of thing that I'm hearing. We sat down, my counterpart and I with Farmers Federation sat down with a lot of the other associations around the state and early on and said, look, here's the situation and here's what the potential impact would be. And they just kind of looked at us and said, y'all fight that battle. So we're just saying, okay, we'll
have to be the last question.
Okay. All right. One more question. Yes, sir.
When you start comparing states to states, you're comparing oranges to apples because
yes.
Some states don't even have a property tax.
Yes, that's
they don't
right.
even have an income tax.
That's right. That's right. You got when you look at the tax burden, you got to look at the big picture. That's correct. Whether you got to put the income tax in with the ad valorem income type of property, ad valorem tax, and sales tax and everything. So yes, you're right. Alabama is a low tax state, unquestionably, but you got to look at that in the big picture. Right now, with all due deference to my friends that work for state government, right now, 1 in 5 workers work in Alabama that have jobs are employed by state or local government. 1 in 5. The national average is 1 in 6. Okay? If we were to get back to that 1 in 6, we could save billions of dollars in the state. So you got to look at this in a broader context. I will say this. The Alabama Forestry Association will continue to fight this battle. We will continue to fight for fair and equitable treatment for forest landowners when it comes to taxes. As we did back in 2003 with Amendment 1, we fought that battle. We are not anti-education. We are not anti-state government. But what we are for is a smaller, more efficient government. And when you have that in place, and I truly believe that that's what this current legislature is working toward, and the governor, within a couple of years, we're going to have a smaller, more efficient government. And then we can sit down and say, okay, what do we need to fund that?